I work here.
Turn around.
I work.
Stand up and turn around.
Okay, I work here, sir.
Put your hands behind your back. Don't move.
More than just that community, it seems like the entire nation was outraged at what they saw. My video got an unprecedented 2.4 million views in the first 24 hours. Also, within that first 24 hours, because there was such widespread public outrage, prosecutors in Volusia County, Florida, dismissed the criminal charges against Paul. The town of Edgewater also quickly responded, putting Officer Rippion on leave pending investigation, and now it's been reported that he's already been fired. Of course, they just used the word separation. I have updates from that. I have updates from Paul's family, but this one was a surprise, or perhaps not a surprise. Daniel Rippion with the founder of Street Cop Training. And in that social media post, Officer Rippion bragged, glad to be at an agency that values good training, Street Cop. You may recall this guy.
Shut the up, right? About to get pepper sprayed, tased, windows broken out, mother.
I featured him in a video a while back because their training was outlawed by the state of New Jersey, with thousands of police officers having to be retrained according to the Attorney General there.
I've made it very clear to all 38,000 sworn officers and their leadership that no one should be attending street cop training.
I've been using Ridge wallets since 2022. I have a ton of them, every color. I have years worth of experience using them. About 6 months ago, a different wallet company, Extra, reached out to me. My buddy Lackluster had been trying to get me to use an Extra wallet for the longest time. 6 months ago, they sent me an Extra wallet to use. I started using it. The things I liked about the Ridge wallet, the minimalism, the RFID blocking technology, still has those. There's just something about a premium leather wallet that has the same features. And also a couple extra spots to store things, like that weird little gym thing that you use to sign into the gym. And there's no other place to put it, especially in a Ridge wallet. When you're paying, you just press the button on the bottom and boom, your cards shoot out. You can pick which one you want to use. The other thing I didn't like about Ridge wallets is over the years, it absolutely would destroy my credit cards. In fact, the one I use all the time, you can see it's all completely frayed, and that was from the Ridge wallet. I haven't seen that occurring with the Extra. They're actually having a Father's Day sale. You can get up to 40% off right now. Use my code TCRL at checkout and get an additional 10% off right now. I want to thank Extra for becoming a channel sponsor. Now let's get back to the video. A 22-year-old Paul doesn't have a car. He's struggling, but he's working. Gets off of work at CVS at 10 o'clock. It's only been 5 minutes. It was actually his sister who called for a lift. He's waiting on the Lyft driver. He's sitting on a bench. He gets up off the bench to put on his hoodie. A police officer on patrol just happens to see this. He believed the CVS to be closed. He believed Paul to be hiding behind a pillar, but no crime was committed. Paul says he wasn't hiding. He was just putting on a hoodie. The police officer then approaches Paul. Paul, who undisputedly had committed no crime, was immediately detained and threatened with violence.
ID card. Something with your name on it.
That's my ride. I'm gonna go ahead and go.
No, you're not.
I didn't break any laws, sir. So
Stop, dude. You can make an emergency, please. I got one resisting.
I work here, sir. I just got off work.
Dude, you're gonna get tased.
Okay, I work here.
Turn around.
I work.
Stand up and turn around.
Okay, I work here, sir.
Put your hands behind your back. Don't move.
And even though the officer discovered that he was wrong, he arrested Paul, charged him with a crime, and took him to jail anyways, where he stayed for 3 days, just to teach him a lesson about what Officer Rippion believed to be his authority as a police officer, even where no crime had previously been committed.
This is my ride. Just 1 second.
Hey, you're good to go. He doesn't need a ride anymore. I'm gonna give him one. You are going to jail tonight. Do you really work here?
I swear to God, I work here.
I do believe that he works here. He's gonna learn, fortunately, the hard way. So. Yeah, I do believe him. He wouldn't fucking ID himself. So. Yeah, he's.
Now, what should have happened is the officer has a hunch, he's suspicious. It's a free country, right? He can go and have a consensual encounter with anyone he wants. He can go up and ask questions. He can ask for ID. He can investigate. And that's what should have happened. This was one of those incidents that really affected people. And it was the people, not just in that community, but nationwide, that achieved some level of accountability here. The charges dropped. They had been pending since, May 10th. Even the prosecutors weren't interested in dropping those charges until people were upset about it. Then the officer's placed on leave, and boom, then he's fired, separated, whatever. What's important about this particular case is that the entire basis of our freedom, of our constitutional rights, it all rests on a foundation of very minor little sort of nitpicky things. The entire foundation of our freedom, of our constitutional rights, rests on what happens in those sorts of scenarios. If we have a government of the people, for the people, by the people, why would we, the people, allow law enforcement officers who are there to serve us, who are there to protect our freedoms, why would we allow them to treat us as criminals unnecessarily? Why would we allow them to treat us with disrespect, with disdain, to seize us first and ask questions later? That's not how it's supposed to be. But if police officers are taught to walk around, to patrol, to interact with the community with an attitude of disrespect, of disdain for the community, with the number one goal of enforcing what they perceive to be their authority, as opposed to serving the public, protecting the Constitution, then we have things like this happen that completely did not need to happen. Nobody called 911. It was just basically a Karen RoboCop going around creating havoc. I mean, how does that happen in the first place? A little over a year ago, I did a video about street cop training, and that was because the Attorney General of New Jersey had basically outlawed it for all the police officers in New Jersey.
In October 2021, about 1,000 police officers attended a private police training conference in Atlantic City. What we found was really disturbing.
Because they discovered this video footage of what happened inside these training seminars for police officers.
The guy in court, you're like, oh, I am not a citizen of the United States under Act 12, 6. Shut the up, right? About to get pepper sprayed, tased, windows broken out, motherfucker. I don't want to hear his exit. I don't want to fucking die at like 91 with hookers and cocaine around me, you know? So, hey, we watched your bodycam videos. We don't think you got a voluntary consent. You hear 7 pieces of case law, fuckhead. Stop trying to bag your 19-year-old dispatcher.
I would be remiss if I didn't remind you or let you know that I have a 3-inch dick.
I'm not the one with the 1-inch dick.
I watched this car come off the highway, and I fucked the shit out of the female driver. She doesn't want to fuck me back, though.
But by that point, street cop training had trained thousands and thousands and thousands of police officers, not just in New Jersey, but all across the country. And the gist of it seems to be you have to be a proactive, tough guy, New Jersey-type police officer who goes out and sniffs out crime. And don't worry about constitutional rights. You have to be proactive. And you have to be aggressive.
We investigated this 6-day conference hosted by a private company called Street Cop Training. Instructors taught unconstitutional policing practices, teaching officers to stop motorists without a lawful basis and to illegally prolong traffic stops.
Have a day where you go out and go, people pull over 20 people in a row for the sole purpose of asking them a series of questions and make up your own questions. Something as simple as, hey, how you doing? Where you come from? You know, hey, where you going? Be real friendly about all stuff and just see how people answer questions. You will learn general baseline.
In Indiana, speed limit for trucks is 65, cars is 70. There's no fucking way that any car should ever be behind a semi if they have the ability to pass it. So when you do that, if you're coming through Indiana, I'm gonna fucking stop your ass. Like, he has the whole left lane to pass this fucking semi, but he's gonna sit right behind it. It makes zero sense. It's not logical.
They denigrated women and racial and ethnic minorities.
I don't want to hear his exit. I don't want to fucking die at like 91 with hookers and cocaine around me, you know? Why wouldn't that be your goal and objective? Like, I'm on vacation in Colombia, money, and these girls like are not as wealthy and they need to do things to make money.
You're trying to get a little booty, nanny, poontang, whatever the hell you call it, okay? There's an approach. You don't walk up and say, hi, what's your name? How old are you? Sounds like casting couch, doesn't it?
They promoted a warrior mentality and glorified violence.
There's nothing else I'm good at. I love violence, I love fighting, I love shooting, and I fucking love freedom. It wasn't that long ago that we were drinking out of the skulls of our enemies. Like, you know, like, I'm gonna fucking murder this guy, then I'm gonna take his head, then I'm gonna cut his head in half, and then I'm gonna boil his skull, and then I'm gonna drink out of that skull.
They belittled internal affairs.
We get kicked in the dick one too many times, when we get in trouble by IA, when we lose our motivation and inspiration. I harped a lot on all the negativity. How many times I got kicked in the dick because they didn't want me to go out there and hit a trap, and they didn't want to hit money, they didn't want to hit me kilo. I hit 15 kilos, I hit 300,000. I'm still getting yelled at. I'm still getting yelled at.
Somebody with some kind of fucking thing on their shoulders or neck collar or fucking whatever. So, hey, we watched your Watch your body cam videos. We don't think you got a voluntary consent. Here's 7 pieces of case law, fuckhead. Stop trying to bag the 19-year-old dispatcher. Get a fucking life.
They dehumanize civilians.
You don't like treating Turks, right? You're like, fuck them. The ambulance can take care of them, right? And I had a problem treating, gangbangers and the people that were the pieces of shit of society, right? I had a great mentor that told me, well, Sean, guess what? That's a live tissue lab, bro. Anytime you come to one of these shitbags, absolutely do the best you can. Absolutely, because what if he gets hurt, right? Or she gets hurt, or he gets hurt, then I can perform that flawlessly because now I've had some reps in. Everybody get that? Everybody with me on that?
They made jokes about their genitalia and harassed members of the audience.
All right, so normally in my class, we open up that beer tap, and I just start spraying people with information. But today, you guys are just gonna get the tip.
I would be remiss if I didn't remind you or let you know that I have a 3-inch dick.
I'm not the one with the 1-inch dick.
I watched this car come off the highway, and I fucked the shit out of the female driver. She doesn't want to fuck me back, though.
That's not an 18-year-old kid dressed like Jesus coming eastbound out of Trenton. It's a 75-year-old black man, a change in drive behavior, came into a gas station, and I'm like, what the fuck? And you know what? Shame on me, because I look in there and I'm like, oh, got a couple small rubber bands. And all I'm doing is asking, hey, what's up with that?
Something like that can just flip the attitude of a police officer from somebody interacting well with their community to somebody escalating situations unnecessarily, such as happened here. That's why I wasn't surprised when I saw this social media post from Officer Ripion. He had attended a street cop training seminar in 2023, and there he is with the founder and CEO of Street Cop Training. And why not take your police officers from Florida and send them to learn from this guy in New Jersey?
Shut the fuck up, right? About to get pepper sprayed and fucking tased. Windows broken out, motherfucker.
CBS News discovered the founder of Street Cop, Dennis Bonino, was a street cop himself in Woodbridge Township, New Jersey. Public records revealed Bonino was disciplined by the department 3 times in 5 years. In 2015, 3 women accused him of using excessive force and racial bias. Woodbridge Township paid $50,000 taxpayer dollars to settle before it went to trial. Bonino never admitted wrongdoing. Woodbridge police say he retired from the department at age 33, weeks after that lawsuit was filed. Then he went on to create Street Cop.
And while they're there, they can also be taught by this guy.
In the South, it's the Wild Wild West, South, wherever. You don't believe me? Run from Georgia State Patrol. Run from me. Somewhere along the chase becomes neither confirm or deny there's some videos out there with me doing just that.
After listening to his story about unconstitutionally shooting at somebody, I was able to go actually find that incident. Obviously, what is the first thing that I went and did when I heard him say that? I searched for the video. Check this out from just a few months ago.
First on the news at 6 o'clock, a Reserve West Baton Rouge Parish Sheriff's deputy who shot into the back of a fleeing car is facing charges tonight.
Sean Pardazzi was fired in February, months after the initial incident took place. He's now facing charges of illegal discharge of a firearm and obstruction of justice.
Vehicle in park.
It was complete insanity for a police department in Florida to send any police officers to go learn from this sort of incompetence and intentional misconduct. Just last weekend, I was speaking with a group of law students, prestigious law students from across the country who were there at the headquarters of the Institute for Justice in Arlington, Virginia, looking into potentially becoming civil rights lawyers, working at a nonprofit law firm such as the IJ. And part of what I was telling them was how important now things like YouTube has become in civil rights and constitutional advocacy. We can file all the lawsuits we want, win the criminal cases that you want, but it's almost impossible to affect real accountability, real change. The one thing that government is afraid of, especially a government that has been bending the rules, is negative publicity, is the public finding out what they've been doing, a light being shined on their bad conduct. That is their kryptonite. And I was telling them, I think my record for one of my videos resulting in a police officer being fired was like 2 days. While I don't think this one beat that, I think we set a new record for the charges being dismissed. And I don't take credit for that at all. What I'm saying is that is you. That is the public reacting to my video and other videos that were out there, all working towards the same goal. Now, in another case, people would disagree, but enough people agreed on that one that the government listened. But there's more work to be done, and I've been in touch with Paul's family, and they're very thankful for all of the help that Paul has received so far, but there's more to be done. I encouraged them to set up a GoFundMe to help in this process, and they did do that. So I'm going to share that GoFundMe link. It will be below. And I'll also point out that in the explanation of what happened and what they want to use the funds for, they explain that Paul was, wrongfully incarcerated for 2.5 days. And that even though the charges have now been dropped, this did result in him no longer being able to work at his job, leaving him with no income to cover rent or transportation. And as a result, he's struggling to find a new place to live. Any donations that you can give will go directly towards helping Paul recover and move forward. Things like legal fees and expenses tied to the legal process, housing support to help him purchase a reliable car to be able to go to and from some hopefully new place of work he finds. So I hope you will join me in donating to hopefully get Paul back on his feet. And also, we're not done, because where is Officer Ripion going to go now? Is he going to pop up somewhere else? Is he going to lose his certification? We're going to stay on top of that, and I need your continued help. So please make sure that you're subscribed. Remember, our rights don't end where you are. 8 months ago, where the cop in Kentucky barges into this woman's home while she's standing there in only a towel, and she correctly says that you can't do this. That's illegal.
You are not legally, this is illegal. Get the fuck out of my house. This is illegal. You just, excuse me.
And the cop says, so file a lawsuit.
It's illegal. File a civil lawsuit.
Well, she did file a lawsuit, and now it's settled. Before I tell you how much it's settled for, in a comment, tell me how much you think her lawyers were able to settle her lawsuit for. Not what you think she should get, what you think she did get. I'll tell you what happened, and we'll see if you're close or if you're right.
He said, if it's illegal, file a civil lawsuit. So I did.
If we want to stay on top of the constant government overreach, we have to be able to consistently and comfortably absorb all the new information. I need audio gear that's reliable and comfortable to use all day, every day. It's not books anymore. Everything now we have to absorb with our eyes and our ears. And that's where Raycon wireless earbuds comes in. These earbuds deliver top-notch sound quality at half the price of the other premium audio brands that have similar features. With 32 hours of battery life and a weatherproof and sweat-resistant design, Raycon earbuds are great whether I'm out in the field or working on a new case here at the office or even out in the gym. They pair seamlessly with my phone via Bluetooth, super convenient when I'm on a call with a client or, most importantly, at one of my daughter's dance competitions. These have active noise cancellation capable of drowning out an auditorium full of screaming girls. And if you need to hear what's happening around you but you still want to listen using your earbuds, it has an awareness mode that allows you to do that. And they're designed to fit the widest range of ears, including mine. These optimized gel tips actually are very comfortable for me, and they stay in. So if you're like me and you want to absorb all the information, go to buyraycon.com/civil rights lawyer, where you'll get 20% off the everyday earbuds. That's right, Raycon is offering 20% off the everyday earbuds when you go to buyraycon.com/civil rights lawyer. You'll find the link in the description below. Trust me, your ears and your wallet will thank you, and I'll thank you also because you'll be supporting the work that I do. Now let's get back to the video. My first video on this situation was from about 8 months ago and focused not only on this actual incident, but also the history of this police officer and the fact that a judge called him out in court. This police officer showed up at this woman's home without a warrant. He said he wanted to make sure that her daughter was okay. When she asked for a warrant, he forced his way inside the house.
Do you have a warrant?
No.
That's illegal. Excuse me, you cannot force your way into my home.
The footage of this shocked a judge who dismissed the criminal charges and laid an epic smackdown on this officer.
Mr. Curtis had zero respect for the Constitution, for which he took an oath and swore to uphold. And quite frankly, I was appalled. I've never seen a video like that.
That police officer resigned, but then he was hired somewhere else. And after a few months, he got fired from there. And as it turns out, this wasn't the first time that he had entered somebody's home and committed violence inside without a warrant or any other lawful justification. He actually was sued for it before. But wait, there's more. Another man came forward with body cam footage that shows this officer trying to collect a private debt using his job and another police officer.
I don't know why he thought he could just intimidate me like that. I don't disagree with you.
So this incident occurred in Frankfort, Kentucky. And by the way, Frankfort supposedly got its name from the 1780s when frontiersman Stephen Frank was killed by Indians at a crossing on the Kentucky River. And that spot became known as Frank's Fort, which eventually evolved into Frankfort. Frankfort is the capital of Kentucky, but it's actually pretty small. Frankfort's population was only around 28,000 people as of 2020, making it the smallest state capital in the United States by population. It's nestled in a deep valley along a bend in the Kentucky River, and it's home to the Buffalo Trace Distillery, one of the oldest continuously operating distilleries in the United States. Legendary frontiersman Daniel Boone and his wife Rebecca. Do you know what her last name was? Rebecca Bryant, a distant cousin of mine. They're both buried, supposedly, in Frankfort Cemetery, perched on a hill overlooking the city. Now to more recent events. It was July 7th of 2023. Kimberly Myers was a 46-year-old mother. She had a career in corporate accounting. But on that particular day, she was just spending a leisurely day at her home in Frankfort with her teenage daughter. Kimberly had just gotten out of the shower. She hears a knock at the door, so she answers the door. Having just gotten out of the shower, she's dressed only in a towel. And it was then she cracks the door open, and that's when she sees then Frankfort Police Detective Larry Gus Curtis with a group of police officers and social workers. Curtis demanded that Kimberly allow him to speak with her daughter.
Social services of Offi just make sure the daughter is okay.
Yeah, she's fine. Thank you. Have a warrant?
I'm sorry?
You have a warrant?
When Kimberly merely asked Curtis if he had a warrant to enter her home, Curtis responded no, but then he immediately shoved the door into Kimberly, injuring her and unlawfully invading her home.
Do you have a warrant?
No.
That's illegal. Iris, you're fine. That is illegal. Excuse me, you cannot force your way into my home. You are not legally. This is illegal. Get the fuck out of my house. This is illegal. You just, excuse me.
Officer Curtis was enraged by Kimberly's assertion of her constitutional rights, so he directed that she be placed in handcuffs and had her arrested on the spot without probable cause, and therefore in violation of her Fourth Amendment rights. As he twisted her arm behind her back with a towel falling off of her, Curtis glibly told Kimberly, if it's illegal, file a civil lawsuit.
It's illegal. File a civil lawsuit.
So she did.
In federal court, she sued the city of Frankfort, the former Frankfort police chief, and Curtis for excessive force and violating her civil rights. All settled with Myers for $350,000. And under the agreement, Curtis can never work for the city of Frankfort in any capacity.
At least I was able to get that in this settlement to at least protect the city of Frankfort from this officer. But there's still an issue of public oversight.
It can really make a difference for the success or the settlement amount of a civil rights lawsuit what type of plaintiff you have who filed the lawsuit. Is this a criminal whose rights were violated, or was it somebody who a jury could sympathize with? Was it a regular person? And it's just as important when it comes to the police officer who was involved. Do they have a history of this sort of thing? Are they a sympathetic individual? Will a jury like them? Or will a jury hate their guts? Have they been fired from other departments? Have they resigned elsewhere? So this was a situation where that was at play on both ends of that. You have this regular mom sort of in a towel answering the door that any woman you're going to have on a jury is going to be able to sympathize with. And then you had this, by all accounts, apparently terrible cop. So according to the lawsuit, and I'll post the entire thing at the blog, it will be linked in the first pinned comment below. So this was the Frankfort Police Department, but Curtis had previously worked at the Georgetown Police Department, and he resigned from there February 1st, 2017, 2 days after being served with a 48-hour notice regarding numerous acts of misconduct. Despite his employment record of numerous acts of misconduct, where he had to leave Georgetown, Frankfort Police Department hired him anyways. But his unsuitability for police work would become evident to Frankfort almost immediately when, in August of 2018, he unlawfully entered the home of two other people, Keontae Russell and Cheyenne Washington. Curtis tased and beat Russell before arresting both of them, all without any probable cause. And that manifested into a lawsuit, which settled before trial. So what does Frankfort do after that happens? Nothing. He received no additional training. He was permitted to remain on the force. He was given no punishment for entering the home unlawfully of a law-abiding Kentucky resident and attacking them inside that home. Instead, Frankfort Police Department promoted Curtis to detective and assigned him to work with vulnerable people such as victims of sexual crimes, children, and people with mental health issues. What could go wrong? According to the lawsuit, during his time there, Curtis amassed numerous citizen complaints and more 48-hour notices, and the department failed to address those issues. Many of those arrests resulted in charges that were dismissed for lack of evidence or significantly amended down. He had a habit of significantly overcharging, which meant that many people would spend substantially more time in custody and would have their families torn apart before the charges were inevitably eventually dropped, as was the case here that happened to Kimberly Myers. Despite all of this, the Frankfort Police Department saw it fit to award Officer or Detective Curtis its 2022 Officer of the Year award. Why? Well, they said because he had a high volume of arrests. The records that Kimberly's lawyers were able to find showed, despite their award, they knew that he had issues. In 2023, Curtis's supervisor specifically stated in his performance evaluation that he had a, quote, tendency to push quickly to a conclusion, and that he should, quote, take note not only of facts that lead to the believed conclusion, but also those that lead elsewhere. And as a result of his false arrest and illegal entry into Kimberly's home, how was she damaged? Well, according to the lawsuit, Frankfort's local newspaper, the State Journal, published the false information created by Curtis, along with her mugshot. It said local mother charged with strangling and assaulting teen. In fact, Kimberly spent 3 days in jail after her arrest in an overcrowded cell in the Franklin County Regional Jail, drinking melted ice from a cooler to try to stay hydrated. Then when that case went to trial, there was a suppression hearing where it was relevant whether or not Curtis followed the Constitution, and the judge was not happy at all. And basically the judge concluded that Curtis had lied and violated the Constitution, and she let him have it at this hearing.
Mr. Curtis had zero respect for the Constitution, for which he took an oath and swore to uphold. And quite frankly, I was appalled. I've never seen a video like that.
Regarding the entry, she said, this is Law School 101. This is the textbook example of the definition of what constitutes an unlawful entry into a person's home. After reviewing the body cam footage multiple times, thinking surely to goodness I had missed something, it instead became glaringly apparent to me that Mr. Curtis had zero respect for the Constitution, for which he took an oath and swore to uphold. I was appalled by the arrogance, and I was incredibly disappointed. And thereafter, Kimberly's charges were dropped, but they weren't dropped until April 16th of 2024, the following year. So remember, in addition to 3 days in jail, in this terrible jail, terrible conditions, the mugshot, accusing her of these terrible things in the community, and having the charges held over her head for almost a year, all of that plays a part in what that case would eventually settle for. It's not just the technical unlawful entry of that home and the arrest of that individual lacking any context. It's the context of this officer's history, the Frankfort Police Department's decision to hire them, everything they ignored, everything they allowed, everything they ratified by giving him awards and promoting him. That all played a part. It wasn't just this one bad officer. It was the systematic lack of accountability that altogether caused the harm to this woman. And the harm to her wasn't just theoretical constitutional injury because he entered her home. She suffered real harm. at some point she would go before a jury and testify about all these things that happened and the effect that it had on her, and a jury could award damages based on that. It's all intangible. But where you have this unlikable officer, you have this likable plaintiff, who knows what a jury would do? They would also have the ability to probably award punitive damages and then damages against the city itself for their part in this. All of that is at play, and it's very difficult to put a number on things like this. And here's my opinion. That is a pretty good settlement for an unlawful entry into a house. It's a pretty good settlement for a false arrest. Again, it depends on all those factors. You have to look at it in context. And if this case had gone to trial, this case had all those different things going for it, which many people don't. Most often, the cops violate the civil rights of people who are not necessarily sympathetic. They have committed some crime. They have engaged in some wrongdoing. They're spouting off on the body cam in a way that a jury is not going to like. Maybe the officer has no prior disciplinary history. The officer wasn't fired at prior departments, and you don't have a judge who has specifically said on the record that this officer has violated the Constitution and is a terrible cop and is not to be trusted. So this case had a lot going for it. So don't be fooled by the number. $350,000, pretty good. There will still be people out there saying, well, it's not enough. It should be $350 million. Yeah, but that's not reality. That's not the real world that we live in. You never know what a jury is going to do. The more common result is that qualified immunity is given to the police officer and you don't even get to a jury. And when you do, when and if you do get to a jury, the most common result is they side with the government. They side with the police because they're not told that the officer doesn't have to pay whatever they award. They're not told that there's insurance. They're not told that the city is going to indemnify the officer. The jury is shielded from that. So when they do award money, they assume the officer himself is going to have to pay it. And unless they're really, really angry at the officer, a lot of times it's a very, very small number. So anyways, that's my thoughts on this settlement. It's good to share that information so that other civil rights plaintiffs around the country can point to it and say, look, here's what happened to that woman. And $350,000 was the mutually agreed upon a settlement amount for that case. And then you can compare it to the facts of some other case and say it should be more or less as compared to those facts. If you like staying on top of constitutional rights and civil rights litigation, please subscribe both here and at the blog at thecivilrightslawyer.com. You can also follow me on Twitter at JohnBryanESQ, where a lot of times I'll post updates that never make it to YouTube. Our rights don't.
Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers traffic stops involving a minor, interfering with an officer, and mistakes of fact and law, and is brought to us by Lackluster's channel. Be sure to check out the description below and give them the credit that they deserve. On January 24th, 2023, Officer Blake Stinson of the Cody Police Department in Cody, Wyoming, pulled over a 17-year-old driver whose name has not been publicly released for allegedly failing to yield to a pedestrian in a crosswalk. The driver was on his way to school with two other minors, and after he stopped, Officer Stinson approached the driver's side of the vehicle. The incident that followed was captured on Officer Stinson's body camera and dash camera, as well as the body cameras of other officers.
When someone's in the crosswalk, you're required to yield to them. I need your driver's license, registration, and insurance.
Yes, sir. Can I call my mom? This is her vehicle.
Yeah, you can provide digital copy of the insurance, but the registration needs to be provided.
Can I ask what I was doing before?
There was somebody in the crosswalk and you almost hit him.
Sir, it's officers. He said there's somebody in the crosswalk and almost hit him. You want to talk to him?
I need your driver. I don't care. I need your driver's license.
He said he doesn't care. He doesn't want to talk to you. I'm not inclined to talk to you without a parent. I'm not 18 years old.
You're driving a vehicle and you're required to give me your driver's license, your registration, and your insurance. Okay? Those three things are required. If you don't provide those things, you'll be placed in custody. Okay? I'm not joking.
You said if I don't provide those things, I'll be placed in custody. I don't know where anything is. Sir, my mom's on the way to help me out.
Okay, go ahead and step out of the vehicle. Step out of the vehicle.
Sir.
I can smell marijuana in the vehicle. Get out.
There's no marijuana.
I'm not going to tell you again. You're going to get out of the vehicle or I'm going to drag you out. Open the door. Open the door now.
My mom's on the way.
I don't care. Open the door now.
My mom down here?
Nope.
You gotta step out.
I'm not 18 years old.
It doesn't matter. I saw a violation. I stopped you for, and you've already talked back to me about getting your stuff out. Get out of the vehicle.
I'm trying to figure out what's going on.
Get out of the vehicle. That's what's going on.
I know I'm allowed to have a parent or
no, you're not.
You're
not.
Lawyer.
You're gonna get out of the vehicle right now, or I'm gonna drag you out. You decide.
Can I talk to my mother?
Nope.
After the driver fails to produce his driver's license, registration, and proof of insurance, Officer Stinson orders him to step out of the vehicle, and the driver claims that he's allowed to have a parent or lawyer present because he is a minor. According to Section 31-7-116 of the Wyoming statutes, quote, "Every licensee shall have his driver's license in his immediate possession at all times when driving a motor vehicle, and shall display the license upon demand of any police officer." Additionally, Section 31-2-204 provides that, quote, "A copy of the certificate of registration shall be carried at all times in the motor vehicle for which it is valid, and shall be displayed upon demand of any peace officer." And Section 31-4-103 requires all drivers to provide proof of liability insurance to an officer who is issuing a citation for a moving violation. It is important to note that the language in these statutes is not limited to adults and applies to all drivers in Wyoming. So the driver would be required to provide these documents to Officer Stinson as part of the traffic stop, despite his age. Furthermore, in the 1977 case of Brewer versus Williams, the Supreme Court held that an individual gains the right to an attorney, quote, "at or after the time that judicial proceedings have been initiated against him, whether by formal charge, preliminary hearing, indictment, information, or arraignment," meaning that the right to counsel does not exist at the onset of a traffic stop. Because minors are not afforded any special legal protections during traffic stops, the driver was not entitled to have a parent or attorney involved in the traffic stop simply because he is a minor. However, it is important to note that a juvenile's age may be taken into consideration during other types of police interactions. For instance, although the U.S. Constitution does not prohibit officers from interrogating juveniles without a parent or lawyer present in all situations, in the 2011 case of J.D.B. versus North Carolina, the Supreme Court held that courts must consider a juvenile's age as a relevant factor when determining whether a suspect is quote-unquote in custody, and therefore entitled to be read their Miranda rights before being subjected to police interrogation. In reaching this conclusion, the court recognized that, quote, "Children generally are less mature and responsible than adults. That," now quoting again, "they often lack the experience, perspective, and judgment to recognize and avoid choices that could be detrimental to them. That," now quoting again, "they are more vulnerable or susceptible to outside pressures." And that, now quoting again, "a reasonable child subjected to police questioning will sometimes feel pressured to submit, when a reasonable adult would feel free to go. Therefore, although a juvenile does not receive extra legal protections during a standard traffic stop, their age may be relevant to other considerations that may arise during police interactions."
Mom,
Get out of the vehicle.
He's dragging me out of the car.
Get out of the vehicle.
Mom!
Get out of the vehicle.
Mom!
Help me.
You get that one.
Get out of the vehicle now.
Mom! Mom, help
You're
me!
told very clearly what to do, and if you're not going to do it, we're going to have to take other avenues. Unlock the door.
I can't, sir. You have my arm.
Okay, then get your knee off of it, because I know what you're doing.
Button, please.
There's not one on that side.
Get your knee off of it, because I know what you're doing. Okay? You're going to go for resisting.
While attempting to remove the driver from the vehicle, Officer Stinson threatens to arrest him for resisting, claiming that his age is irrelevant. According to Section 6-5-204 of the Wyoming statutes, an individual commits the offense of interference with a peace officer if they knowingly obstruct, impede, or interfere with a peace officer engaged in the lawful performance of their official duties. As the Supreme Court of Wyoming explained in the 2020 case of Garza versus State, under this statute, interference is defined as checking or hampering the action of officers, or doing something that hinders, prevents, or tends to prevent the performance of an officer's legal duties. The court also noted that, quote, "interference does not require the use of actual direct or threatened force," and that, now quoting again, "a peace officer may be obstructed, interfered with, or impeded in the lawful performance of his official duties by speech," before ultimately concluding that an individual's verbal refusal to allow an officer to draw his blood in the execution of a search warrant was sufficient to constitute interference. Likewise, in the 2011 case of In Re CG, the Supreme Court of Wyoming upheld a delinquency adjudication for interference against a juvenile who refused an officer's instruction to exit a vehicle and braced herself against the driver's seat when he tried to remove her. It is important to recognize that in this situation, although the driver may be able to argue that he did not knowingly interfere with the officer's attempts to remove him from the vehicle, as he was physically prevented from unlocking the vehicle door by the officers holding his arms out the window, courts have found a verbal refusal to comply with a lawful order to be sufficient to prove an interference charge. Therefore, assuming that Officer Stinson was acting with lawful authority when he ordered the driver to exit the vehicle, it is likely that a court would conclude that the driver's refusal to exit the vehicle constituted a violation of the interference statute. As to Officer Stinson's assertion that the driver's age is irrelevant, juveniles can generally be arrested for conduct that violates criminal statutes, and under Wyoming law, they can be tried in traditional courts or in juvenile court. Section 14-6-203 of the Wyoming statutes provides that, quote, the juvenile court has concurrent jurisdiction in all cases in which a minor is alleged to have committed a criminal offense, and, based on various factors, the district or county attorney has the authority to commence such cases in either juvenile or criminal court. Therefore, Officer Stinson is correct in his assertion that the driver could be arrested for obstruction, despite the fact that he is a minor.
Dude, it doesn't matter how old you are.
Open the door, man. Seriously, is this worth it?
I'm on the way. I don't care. I told you to open the door.
It doesn't matter. Open the door.
It doesn't matter how old you are. That has nothing to do with this.
Passenger, unlock the door.
There's not one over
there. We go. Hold on.
When you don't do what you're told, this is what happens. He almost hit somebody in the crosswalk right here at the courthouse. The dude had to stop and like back up for him to go through, and then he wheels in here and I stop him. He doesn't have a license either.
Officer Stinson claims that the driver almost hit a pedestrian in a crosswalk and that the pedestrian had to stop and back up. However, the dashcam footage appears to show that the pedestrian entered the crosswalk after the driver had passed it, or at the very least at the same time as the driver was passing. While Officer Stinson's dashcam clearly shows that the driver did not almost hit the pedestrian, Section 31-5-602 of the Wyoming statutes provides that, quote, the driver of a vehicle shall yield the right of way by slowing down or stopping, if need be, to yield to any pedestrian within or entering a crosswalk. Unfortunately, there is no available case law that analyzes what precisely it means for a pedestrian to be quote-unquote entering a crosswalk, but it would certainly be within the realm of possibility for a court to conclude that the statute requires drivers to yield to pedestrians who are on the sidewalk and about to enter a crosswalk. And under this interpretation, a court would likely conclude that Officer Stinson had at least reasonable suspicion, if not probable cause, to stop the driver for failing to yield. Additionally, even if a court ultimately concluded that the statute did not require drivers to yield to pedestrians who had not yet stepped off the sidewalk, or if the evidence showed that the pedestrian actually did not begin to enter the crosswalk until after the driver had passed, a court could still find that Officer Stinson had reasonable suspicion to make the stop. In the 2014 case of Hine versus North Carolina, the Supreme Court held that both reasonable mistakes of law and reasonable mistakes of fact can provide sufficient grounds to justify an investigatory traffic stop because, now quoting, reasonable suspicion arises from the combination of an officer's understanding of the facts and his understanding of the relevant law. The officer may be reasonably mistaken on either ground. Therefore, it is likely that a court would uphold the constitutionality of Officer Stinson's traffic stop if it concluded that Officer Stinson was reasonably mistaken in his observations of the facts of the situation or his understanding of the law, even if the driver was ultimately found not to have failed to yield to the pedestrian.
What was your reason for pulling him over?
Huh?
What was your reason for pulling him over?
Failure to yield to a pedestrian.
Who did it, Stinson?
Yes.
Stinson follows this kid all the time.
Okay, that's perception, but that's what's
I
going
know.
on right
I have
now.
witnesses that have been in the car with him, and Stinson followed him for miles down Bighorn Avenue for no reason whatsoever.
Okay. I need you to step back from the car. Don't step forward towards the car,
Can I see
please.
my kid?
Not right now. Okay.
After the driver was arrested, officers found marijuana and nicotine in the vehicle, and he was charged with interference with a peace officer and possession of a controlled substance. However, the charges were dismissed without prejudice 4 months later for procedural reasons, according to Cody Police Chief Charles Baker. After the Cody Police Department received a formal complaint from a member of the public, Officer Stinson was placed under paid administrative leave, and the department launched an internal investigation into the encounter. Notably, this investigation was completed by Sergeant Justin Justin Weed, who was also involved in the traffic stop. Although the department investigation concluded that Officer Stinson's account of the incident was corroborated by the pedestrian using the crosswalk, the city stated it would also be hiring a third party to review the city's investigation, findings, and department policies. However, as of the date of writing this episode, no further information on this review has been released. It is unclear whether the driver and his family intend to pursue legal action against Officer Stinson or the Cody PD. Overall, Officer Stinson gets an F for maintaining an aggressive and impatient demeanor throughout the encounter, blatantly misrepresenting the nature of the potential traffic violation involved in the stop, and yelling at the minor driver to unlock and open the vehicle door while both of his arms were being held out of the window. Although Officer Stinson may have had a legal reason to conduct a traffic stop, the anger he directed at the driver was completely out of proportion to the severity of a minor traffic violation. And while I understand that some of the driver's actions were likely frustrating, Officer Stinson's ill-tempered behavior was entirely unprofessional, particularly given the fact that he was dealing with a minor. Additionally, Officer Stinson repeatedly exaggerated the reasons for the underlying traffic stop to make it seem like the pedestrian was in potential danger.
There was somebody in the crosswalk and you almost hit him. He almost hit somebody in the crosswalk right here at the courthouse. The dude had to stop and back up for him to go through, and then he wheels in here and I stop him. He doesn't have a license either.
In reality, the dashcam footage clearly showed that the driver did not even come close to striking the pedestrian. And although it may have been reasonable for Officer Stinson to believe that he violated the failure to yield statute, his visual observation should have clearly precluded any interpretation of the situation that involved the driver almost hitting the pedestrian. As for the driver, it would not be appropriate to issue a grade to a minor who has likely never had a negative experience with law enforcement or been educated on how to properly navigate a police encounter. This interaction highlights the importance of educating young adults about their constitutional rights and the role and authority of law enforcement officers. Considering that very few public school curriculums cover anything related to this topic, resources like flexyourrights.org can offer valuable information to individuals who want to learn more about their rights and police interactions. And there are a host of other resources available for free to learn more about this subject, like the channel you're watching right now. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content. Of the North Richland Hills Police Department noticed a Texas driver named Travis traveling down a busy highway near the 7200 block of Northeast Loop 820. Officer Victorious followed Travis for several minutes before eventually initiating a traffic stop based on his alleged observation of Travis crossing a solid white line on the roadway. The interaction that followed was captured on both officer dashcam and body-worn camera.
Name and badge number. Noticing those police department, Officer Victorious, you got your driver's license on you? Name and badge number? Do you have your driver's license on you? Victorious 936. Reason for the stop, you disregarded a traffic control device there. You crossed solid white lines. I did. Do you have your driver's license on you? Yeah, I do. Okay. Any weapons in the car? No. Okay. You been in North Richland Hills? The offense he committed was in North Richland Hills. Yeah.
Oh, what? Yeah. Is it on Dash Street?
Yeah, all recorded.
Excellent.
Yep. It's all recorded.
Body camera on?
Yep, sure is.
Why is the red light on?
See the little recording button? That means it's on.
Excellent. And you realize you had your brights on in my eyeball.
Okay.
Just scratch that cornea. That's right. So your brights into my eyeball, posing a hazard.
Anything illegal in the car that you know about? No. Okay.
After I asked you, and you
all right, same vehicle.
Good. Yes, sir.
Do you need to record?
I know. Cool. And what was your badge number again?
936.
936. And you claim this infraction occurred in North Richland Hills, but you waited until outside North Richland Hills to pull me over?
infraction occurred on road.
So why didn't you pull me over and nothing else?
When it occurred, I pulled you over.
I was driving straight.
We're not going to argue it out here. I got you on video camera crossing solid white
got
lines.
my license?
Not right now. You're detained. You're not free to go.
I'm detained?
You're not free to go.
Okay. What's your reasonable suspicion of an actual crime, not a traffic violation?
Northwest 333, negative, good.
You're detaining me, right? Or am I free to go?
Simple, thank you. You're not free to go.
No.
So you're in a traffic stop right now?
Detained?
Correct.
Right.
You're not free to go.
Okay.
So if you leave, it's going to be a charge. Okay.
That's detainment.
You see the traffic stop? You are not free to go.
Detaining is for an arrest. A probable cause you would need for detainment.
So disregarding the traffic control device?
Yeah, so, that's just...
Okay.
Make sure we're on the same page. And
you're not free to leave.
Between the
you're not free to leave.
And a traffic stop.
Okay. You are not free to leave.
There you go.
To make that clear? Cool. Thank you. Please don't leave. I don't want to charge you with evading.
Why
we
would
agree
I
on
leave?
that?
I have nothing to run from.
All right. Cool. No weapons in the car?
Nope.
Okay. Nothing illegal in the car to know about?
I don't know how to answer any more questions, but go ahead.
If you don't want to answer questions, that's fine.
Are you drawing my ticket, or?
I'm waiting for dispatch to come back with your return.
So you have 20 minutes.
Okay.
Sometime it's up.
Oh. Sounds good. We can sit here and stare at each other for 20 minutes if you like.
Did it upset you that I asked you to turn my lights off?
I turned them off for you. I turned them off for you. I did. I did.
And then I go back around and ask,
Correct. You're up.
And then I pull back up and bam, right there they are again.
You might keep your right hand on the steering wheel, please. Thank you. I appreciate it.
Whatever makes you feel safe.
I appreciate that.
You waiting for dispatch to come back with what?
I'm just waiting for dispatch right now to come back with your return.
With my return?
Yeah, I gotta run your driver's license, make sure it's valid.
Yeah, you do that in your computer system.
Well, I gotta go to dispatch. I'm out here with you.
Took my license, come back to the vehicle.
Okay.
Legally, I hand over my license.
Sorry?
Legally, I don't have to hand you my license.
Well, if you wanted to go down that route, that'd have been a different ballgame. So I appreciate you handing me your license.
Yeah.
Thank you.
You have my name, you have my address, you have my license plate, so can I have my license back?
No. So you committed a violation. Okay.
So you claim.
So you're not free to go. Okay? That's where we are right now.
Anyway.
Hey, innocence of proven guilty, right? So that's where we're at.
So yeah,
that's where we're at.
A little bit of a retaliatory stuff, but you know.
Okay.
You literally followed me.
What
After
says?
blinding me
What says?
twice.
What? Okay. However you want to put it. Okay.
Followed me every which way. Why was that?
I can patrol anywhere in the city.
Oh, absolutely. You're at about 10 minutes.
Awesome, right on time. North Coast 333 guys, so you're gonna get a AA one time to my location, please. You probably need more like 7,900. 1015. 1015. Step out. Sorry. Step out. Badge number, sir. All right, turn around. Put your phone turn around. Turn around. You drop it in there. Everything is recorded. You are under arrest. Disregarding traffic control device.
Officer Victorious and Officer Burks placed Travis under arrest for allegedly, quote-unquote, disregarding a traffic control device in violation of Section 544.004 of the Texas Transportation Code. Contrary to popular belief, most offenses, regardless of how trivial or victimless they may be, still authorize officers to make an arrest, particularly when the offense is committed in their presence. Section 543.001 of the Transportation Code expressly authorizes an officer to make a warrantless arrest when a citizen is found committing a violation of Subtitle C. Now, since Section 544.004 is part of Subtitle C, the Transportation Code itself gives an officer the statutory authority to arrest for that violation when it is committed in the officer's presence. Furthermore, in the 2001 case of Atwater versus City of Lago Vista, the Supreme Court held that the Fourth Amendment does not forbid a warrantless custodial arrest for a minor criminal offense punishable only by a fine so long as there is probable cause. In addition, Section 543.004 of the Transportation Code makes issuance of a written notice to appear mandatory for a limited set of specified offenses, and it also clarifies those are the only offenses for which issuance is mandatory. Disregarding a traffic control device under Section 544.004 is not one of the offenses listed in Section 543.004, which means the Transportation Code does not force a written notice to appear for this particular charge in the same way that it does for offenses like speeding. Therefore, it is likely that a court would view Travis's arrest as technically lawful. However, that does not mean that every custodial arrest for a minor traffic violation is consistent with the spirit of how Texas law expects these encounters to be handled. Chapter 543 lays out a clear notice to appear framework that is designed to resolve routine traffic misdemeanors through a written notice and a release from custody rather than a full booking process. When an officer arrests a citizen for a misdemeanor traffic violation and does not take the citizen before a magistrate, then Section 543.003 requires the officer to issue a written notice to appear. The point of a legal framework involving a cite and release format is to avoid unnecessary arrests for minor violations. Additionally, Section 311.17 of the North Richland Hills Police Department's General Orders outlines the protocol for arrests involving Class C misdemeanor charges. Now, while this policy does acknowledge an officer's discretionary authority to make an arrest based on such a low-level crime, it also highly discourages arresting citizens based on Class C misdemeanors, and states that, now quoting, officers are encouraged to issue a citation in lieu of arrest in all situations where no greater investigatory or legal objective exists. Here, there does not appear to be any greater so-called investigatory or legal objective that influenced Officer Victorious's decision to arrest Travis, and there is a strong argument to be made that the arrest did not comply with the intent of the department policy, if nothing else. Before we continue the interaction, I want to give a big thanks to the sponsor of this episode, Incogni. If you've ever watched one of these interactions and thought, man, I don't want random people knowing where I live, here's the uncomfortable truth. A lot of the time, they already can. Not because you posted it, but because there are entire businesses that vacuum up your name, address, phone number, email, relatives, and other details, then publish and sell it through people search sites and data broker databases. That's why I use Incogni. It's a hands-off service that goes after these companies on your behalf and gets your info removed. You create an account, share the minimum info needed to find your profiles, give a one-time authorization, and Incogni handles the removal requests and the follow-ups. And the feature I really like is custom removals, which comes with their unlimited plan. If you find a specific page exposing your info that isn't part of their automated network, you can drop the link into your dashboard, and a dedicated privacy expert will work on getting it taken down if it's eligible. Incogni is also the first and only personal data removal service to be independently verified by Deloitte, which matters in a space that's full of sketchy promises and shifty businesses. Right now, Incogni is offering members of the ATA community a 60% discount on an annual plan when you use code THEAUDIT at the link below. Data doesn't just disappear on its own. If you don't take it back, someone else will. Thanks again to Incogni for sponsoring today's episode.
Correct. It's an arrestable offense in the state of Texas, sir. Anything illegal on you need to know about? It's a felony to bring it to the jail, okay?
Roll my window up and walk my vehicle. Your car's gonna get towed.
Alright. Let's walk this way. Alright, stand right here for a second. Spread your feet.
Correct. You can't stand in my way. Really hoping you find something, but you won't.
We'll check everybody before we go in the car, man. Do you want this with you, or do you want this in the car?
Actually, I'm going to give you permission to search, but yeah.
Okay, well, I'm searching the incident to arrest. Okay. Hey, Travis. Travis. Hey, the jail's not going to take this. We're going to leave it in your car, okay? Spread your feet. Spread your feet. I mean, if you bring it with you, they're just going to throw it away at the jail, so it's up to you. This way? We're going to leave it right now until you get to the car. Will you grab my phone as well? We'll grab it for you. Alright, take a seat.
After placing Travis in the back of the patrol car, the officers mute their body cams and decide to search Travis's vehicle. Now, in general, for an officer to conduct a search, they must either obtain a warrant or satisfy certain criteria for an exception to the warrant requirement. While a search incident to an arrest is typically regarded as an acceptable exception to the warrant requirement, the scope of such a search is limited. In the 2009 case of Arizona versus Gant, the Supreme Court held that officers may search a vehicle incident to a recent occupant's arrest only when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search, or when it is reasonable to believe that the vehicle contains evidence of the offense of arrest. Once Travis was handcuffed and placed in the patrol car, he was no longer within reaching distance of the passenger compartment, which eliminated the officer safety and evidence destruction rationale that originally justified searches incident to arrest. More importantly, a traffic control device violation is generally proven by the officer's observation of the driving conduct and the existence of the traffic control device itself, which means there is rarely a reason to believe that a citizen's vehicle contains evidence of that particular offense. When the offense of arrest does not generate discoverable evidence inside the car and the arrestee cannot access the passenger compartment, then the Gant ruling treats the search as unreasonable, unless another exception to the warrant requirement applies. The only other warrant exception that could conceivably apply to this encounter is a so-called inventory search due to the fact that Officer Victorious intended to have Travis's car towed. Inventory searches are viewed differently from investigative searches because they are justified as a caretaking function designed to protect property, protect officers from claims, and address safety concerns. In the 1976 Supreme Court case of South Dakota versus Opperman, the Supreme Court held that not only are inventory searches themselves considered constitutional, jail, but any illegal items found during a lawful inventory search are not subject to constitutional protection. However, in the 1990 case of Florida versus Wells, the court made clear that an inventory search cannot be untethered from policy, particularly when it comes to opening closed containers, because the absence of meaningful standards turns the inventory into an exercise of pure discretion. As shown in the body cam footage, the officers entered areas of the vehicle that were not within Travis's immediate control, including the back seat and floorboard, but did not remove any items from the vehicle or appear to inventory anything inside the vehicle. The tow receipt from the police department does not note any itemized list of anything that was inventoried from the vehicle, and it ambiguously reads, and I'm quoting here, "Item all over." It is unclear which Fourth Amendment exception, if any, the officers assumed that they were operating under, but it does not appear as though they would qualify for the exceptions that would typically apply to the facts of this encounter. After completing the search with their body cams muted the entire time, Officer Victorious returns to the patrol car to speak to Travis.
Hey, your phone fell on the side, so we have to find it, okay? I stopped the video camera for you so it wasn't recording the whole time, but everything's recorded.
You didn't find my keys?
Well, so, okay, so...
my vehicle.
You want me to finish? You want to talk? All right, cool. So we're grabbing the keys right now. We're going to leave your car key, though, because if we keep the car key with you, they're going to charge you extra for the tow. So we're going to leave your car key with them. All your other keys are going to come with you. Okay? Sorry, sir?
You gonna roll up the window?
Yeah, well, I mean, they're gonna close all that up before they tow it.
Well...
Thank you, sir.
You know, you didn't have AC really going?
Yes, sir.
You left me in a hot vehicle. Texas.
You feel it?
Yeah.
Okay.
I do.
I'll turn it up.
Travis was transported to jail, where he was initially booked for disregarding a traffic control device. In his official report, Officer Victorious neglected to clarify what exactly led to Travis's arrest, and the report simply reads, "Travis was placed under arrest for disregarding a traffic control device. After completing the booking process and spending just over 2 hours in jail, the supervisor on shift, Sergeant Boyd, reviewed the body camera footage of the arrest and determined that the arrest was invalid. Sergeant Boyd immediately requested to have the charges against Travis dropped, released him from the jail, and then returned his property."
Hey, they dropped all charges and released me because obviously nothing was actual on camera. I'm sitting here with Sergeant Boyd. I'm outside.
Okay. You can pick up your car tonight between 9 and 9:30 p.m. Okay. If you don't make it there by 9:30, they won't have anyone there to release it to you. Otherwise, 8 to 5 tomorrow. Okay?
Yeah.
Answer that question.
Where did you come from?
I'm a patrol supervisor, so I have to review every time an officer makes an arrest. They send a report and I review it. And you know, in this case, I didn't felt like there was an offense, so that's why we you know, cops aren't perfect, and I know you don't.
He followed me with every intention of arresting me.
I don't want to, you know, make any excuses for you because, you know, at the end of the day, I agree that we messed up. So, but cops aren't perfect. That's why we have checks and balances. That's why a supervisor has to review the stuff.
Why we have civil rights.
I agree.
After being released from jail, Travis, along with Sergeant Boyd, waited in the jail parking lot for Travis's ride, and he left the scene without further incident. It was later learned that Officer Victorious added a supplement to his report explicitly noting that Travis's action did not constitute a violation of the Texas Traffic Code, and that a citation dismissal form would be completed. Following the encounter, Travis submitted a public records request for the body and dash camera footage of the incident, and went on to file a pro se lawsuit against the city of North Richland Hills, the North Richland Hills Police Department, the North Richland Hills Jail, and officers Victorious and Burks. The lawsuit was filed just over a month after the interaction occurred, and it includes allegations of unlawful seizure, false arrest, false imprisonment, denial of medical care, and several other constitutional and statutory violations. As of the date of writing this episode, Travis's lawsuit remains pending. Overall, Officer Victorious gets an F for effectuating a totally unnecessary and clearly retaliatory arrest, for demonstrating fundamental misunderstandings regarding department policy and Texas law, and for maintaining a condescending and punitive attitude throughout the encounter. It is glaringly obvious that this traffic stop should have ended with a citation and release. And Officer Victorious effectuated what could arguably be reduced to a retaliatory arrest. Travis's request for the officer's name and badge number was a basic accountability question, and Officer Victorious reacted as though it was a challenge that needed to be shut down, and his condescending demeanor was repeatedly on display in how he spoke to Travis, including his fixation on control language about Travis not being free to leave, and his willingness to threaten additional charges if Travis attempted to end the encounter on his own terms. The net effect was an encounter that felt less like traffic enforcement and more like punishment for a citizen who was recording and refusing to be deferential. The arrest decision was the point where Officer Victorious's judgment became indefensible. As discussed earlier in the video, Texas law can authorize a warrantless arrest for certain traffic offenses committed in an officer's presence, and the Fourth Amendment does not categorically prohibit a custodial arrest for a fine-only offense when probable cause exists. That technical authority does not excuse using the most intrusive option available when there was no apparent investigatory objective, no safety issue, and no need to take Travis into custody to resolve the alleged offense. The legal framework discussed earlier also emphasized that Texas traffic enforcement is generally structured around a notice to appear process for routine misdemeanors, and the department's own policy discouraged custodial arrests for Class C misdemeanor conduct when no greater legal objective existed. Nothing in the video suggested that any greater objective existed here, and Officer Victorious's insistence on a custodial arrest read like retaliation for Travis's tone, not an enforcement decision shaped by necessity. Furthermore, after Travis was handcuffed and secured in the patrol car, Officer Victorious and Officer Burks muted their body cameras and proceeded with a vehicle search. As discussed earlier in the video, Arizona versus Gant limits vehicle searches incident to arrest once the arrestee is secured and there's no reasonable basis to believe that the car contains evidence of the offense of arrest. And a traffic control device violation is typically proven through the officer's observation of driving conduct and roadway markings. The search activity shown on camera did not resemble a standardized inventory process, as the officers entered areas of the vehicle without any visible effort to document or catalog property consistent with a caretaking inventory function. It is important to note that this was an instance where the department's own accountability mechanisms served their purpose and acted quickly to resolve the issue. Now, while this fact by no means excuses what happened to Travis, it does show a level of accountability and urgency that is not typical of other departments. Nonetheless, this interaction highlights how quickly discretionary authority can become an abuse of authority when an officer treats a citizen's attitude and recording as justification to escalate, instead of grounding enforcement decisions in legitimate objectives and measured professionalism. Now, as for Travis, he gets an A-, because although he could have invoked his right to silence more tactfully, he remained calm and collected throughout the encounter, complied with the orders of the officers despite believing the arrest to be unlawful, and followed up this encounter with the proper legal action. Travis maintained his composure and remained nonviolent while being subjected to an arrest that he believed was unjustified, and he did so even after it became blatantly obvious that the officers were not interested in resolving the encounter through the least intrusive means available. He repeatedly asked clarifying questions about whether he was free to go. He disputed the basis for the stop and the arrest verbally rather than physically, and he complied with instructions during the arrest and transport despite expressing that he viewed the situation as retaliatory. The primary issue with Travis's conduct was not his demeanor, but his decision to argue legal principles in real time with an officer who was already exercising control in a punitive way. It is also important to note that several of his assertions about legal standards were inaccurate, including the notion that the officer had a fixed time window to complete the stop, and the suggestion that a detention concept only applies at the arrest stage. Those kinds of claims very rarely improve a driver's legal standing in the moment, and they tend to expand the conversation in a way that gives an irritated officer more openings to prolong the encounter, escalate the tone, or justify additional steps that would not have occurred if the driver had kept the exchange minimal. Travis spoke too often and missed the simplest and most practical constitutional protection available to him, which was to invoke his right to remain silent once he had clearly communicated that he disagreed agreed with the officer's actions. He did not need to persuade Officer Victorious on the roadside, and continuing to banter after the decision to arrest had already been made served no practical purpose. That said, Travis still did what most citizens do not do after a bad encounter. He obtained and released the footage and pursued accountability through formal legal channels, rather than pursuing accountability through a roadside win. This interaction highlights how a citizen can preserve their safety and credibility through calm compliance and proper follow-up, while still improving their position by avoiding roadside legal debates and relying more heavily on disciplined silence. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out Audit the Court if you're interested in learning about the legal nuance beyond the body cam.